Good morning. Selamat pagi. Welcome to Zaid Ibrahim Podcast. I refer to yesterday's report, the courtroom speech by Tan Sri Azhar Harun in the defense of his client, who was charged with contempt of court. It was a very spirited and principled argument, and I urge lawyers and law students to read it. His words should embolden the legal fraternity to reflect deeply on the evolving role of contempt laws in a modern judiciary. Today, we face an alarming proliferation of contempt cases in the Sharia courts, in the civil courts, hundreds of cases. Of course, the more famous cases involve Malaysia Kini and a few lawyers in 2019. And what was once a rare and serious recourse has now become a frequent weapon, sometimes used more to shield the bench from criticism than to protect the administration of justice. To be clear, contempt in the face of the court, like disruptions during proceeding, defiance of court orders, or acts that compromise courtroom order, can be justified. Such conduct threatens the integrity of the judicial process and warrant immediate sanction. But the continued use of contempt for the so-called offences like scandalizing the court or bringing the judiciary into disrepute, it is both anachronistic and unjustified in the context of a democratic society and a modern judiciary. Why do I say that? The origin of contempt laws lies in different time. In the 16th century, the public anger at the monarchy in Britain often spilled over into the judges, who were seen as mere instruments of royal power. To shield themselves, judges developed contempt laws as a form of legal armor, not to protect justice, but to protect themselves and the king. These same principles were exported by the British Empire to its colonies, including Malaya, where they become convenient tools to silence dissent and suppress anti-colonial voices under the guise of protecting judicial dignity. But those days are over. It's over. Today, Malaysian judiciary is no longer a tool of kings or colonial masters. It is constitutionally enshrined, independent branch of government, capable of defending its legitimacy through its judgments, transparency and ethical standards, and ethical conduct of judges. The dignity of the court can and must rest on the strength of their reasoning, not the silencing of dissent. If the courts wish to be respected, they must earn it through fairness, impartiality, and moral authority, not through threats of fines and imprisonment against those who dare to speak critically. Respect is already granted in courtroom in the courtrooms. Judges are addressed as my lord, young Arif, young Ahmad Arif, and they wear special robes, and they carry esteemed titles. Is that not respect enough? To then wield contempt laws to punish citizens, whether lawyers, journalists, or ordinary people, simply because they disagree with the decision or question judicial conduct, is to confuse criticism with subversion. We must move away from this colonial reflex. We must move away from this habit to punish speech. We should instead demand that the Attorney General's chambers codify contempt laws in a modern, rights-respecting statute, one that discards outdated common law concepts like scandalizing the court. What is that? The AG should focus on clearly defined, narrowly tailored offences that genuinely threatens the administration of justice. That's all you need to do. Above all, we must remember this. This idea of this free expression and fair comment and criticism by the public are not threats to the justice system. They are its lifeblood. Yes, judges are special, but they are not so special as to be above criticism or to command obedience by fear. The true strength of a judge lies not in their power to punish, but in their ability to convince, to persuade, and to be just. So, ladies and gentlemen, and lawyers, I hope you take this message seriously. Thank you.